Hello everyone, this is Chidam Kneval. Thanks for joining us today on our 2018 Parents Dyslexia Summit. Our guest today is Robert Thurston. He has been practicing law for over 30 years and his practice focuses on special education. And he manages schoolskidslawyers.com. Robert has been an adjunct professor at McHenry County College and Harper College as well. Robert has two teenage sons, both with special needs, so he does bring a perspective both as a lawyer and a parent. Thank you so much for joining us today, Rob.
Oh, thank you for having me. I really am looking forward to this.
So we met about a year ago on a Decoding Dyslexia event here in Pennsylvania, and I realized that there's a lot more to dyslexia and special education law than what I have seen just based on my experiences as a parent. And I was very impressed on the perspective you brought around the federal level and then going down to how you can each help every single individual based on their individual needs. So I thought that bringing your perspective would be helpful, and not that every parent would need a lawyer, but it would be nice to know what their rights are and when do they need an advocate, when do they need a lawyer, and how do you guide your clients through this process if there's a need. So thank you again so much for joining us.
Sure, absolutely. And I'm happy to answer any questions.
So maybe we can start a little bit with your background, and you can maybe tell us about your parents' side, because most of our listeners are parents. And I know I really felt a connection with you when you told me how you decided to go into special education law.
Sure. So my oldest son was the start of this. When he was 9, which is actually kind of late, he was diagnosed with autism. And I didn't know anything about autism. I certainly didn't know anything about special education law. So I, as probably most parents do, when they get a diagnosis for their child, they read and read and read and try to learn everything they can about that. And that's what I did. I read all this about autism. So, and that was my focus as a parent, figure out what was best for my child and how I could help my child with that diagnosis. But then what happened is right around that same time, he started having difficulties in school. I was getting called to school almost on a daily basis because they were just telling him, well, he's misbehaving and this and that. And then I started hearing some horror stories where literally the principal one day was sitting on top of my son with her knees on his chest. There were some other times when he was put into an isolation room, and some other things that I just was like, something seems wrong here. So now I had already been a lawyer for about 20 years almost at that point. And I said, well, wait a minute. I said, there's got to be some laws that talk about this. So I did. I did now my research on the law side. And I said, look, I not only need to help my child with the parent side, but I need to now help my child on the law side. And that kind of brought this all to a head. And then after I was able to help my son, I realized, you know what, there's probably hundreds, if not thousands and millions of parents out there who have kids with disabilities who have no idea this law exists and how it can help their child. So that started me on my mission, so to speak.
And that's a wonderful story. So I'm sure that all of us can relate to that at a different level. If you look at the law, as you said, there's a state law and then there's a federal law. And for those parents who might not be very familiar with it, maybe you can give us a little bit of history how the special education law developed and how IDA came about.
Okay, yeah, great. So starting at about the 60s and early 70s, there was a number of laws that came out that were designed to help children with disabilities in school. And this is actually even before IDEA existed. And so those early laws, they made some good attempts and they were all done with good intentions, but they fell short. And then finally, IDEA came along in its first instance and basically said that, look, the prior laws were not doing what they were supposed to do and not really helping children, not really helping parents. So IDEA came along and they made substantial improvements. And IDEA, as we know, is the Individuals with Disabilities Education Act. And that's a federal law. And then it was amended in 2004 to what we basically have today. Now, let me tell one misconception about this that I think is really important for parents to know, and that is the law is primarily federal law. People think that, you know, state laws are the ones that are at play here, and that's not really true. Now, I'll explain how that works, because, and schools use that to their advantage, by the way. Schools will tell parents, well, that's not what the state law says. Well, they're baloney, basically, is what they're talking. So federal law is more important than state law. Okay, there's a hierarchy of laws, and federal law is the most important one. And so IDEA law and some other laws, 504 and ADA, that all apply to children with disabilities and students with disabilities is federal law. Now, states can only make that law stronger. They cannot make that law weaker. So now, to the extent it makes it stronger, that's good for the children. But most of the time, we look to the federal law as determining what the rights are for these kids and these parents.
That makes sense. That's a great explanation. So if a state wants to take it a step further, that is great, because then, as you said, it's more help for the children. But they can't go further back and say, well, we're not going to give the support because that child has that right under the federal law. That's a great guidance. So what are some of these key laws that are out there that help these children who do need it?
Okay, so we talked about IDEA, and that's the main one, and because that is specific to children with disabilities in school. And so, you know, for example, and when we're talking dyslexia specific, so IDEA law defines a child with a disability. And kids with dyslexia come under the category of what's called specific learning disability. Now, there are 13 categories that make you eligible for protection under IDEA law, and that's the one where dyslexia falls. It's called specific learning disability, or SLD. And here's a mistake I'll point out that a lot of schools make. They will put the child with dyslexia under the category other health impairment, OHI. That's absolutely wrong. It's a wrong categorization, and I think they do it intentionally because the parents might not know that's wrong, and therefore they can also limit what services they provide to that child. So that's a little bit on that. The other part of IDEA I wanted to emphasize is called child find, and that's a law that requires schools, if they suspect a child has a disability, it requires the schools to follow up with that, have the child tested, see if this child has a disability that would enable him or her to get some additional protections and services at school. So that's another key part of IDEA law. I'll come back to an important part of the IDEA law in just a second, but to highlight some of the other laws, there's what we call Section 504. And there's a lot of misconceptions about this law. This is actually an anti-discrimination law. And what it is, and 504, by the way, is for a person's entire life. It's not just when they're a student. IDEA law is more geared towards when they are a student. Up until the point they either graduate high school or they're 21 years of age, whichever comes first. But after they're 21 or graduate high school, IDEA no longer applies. But 504 does still continue to apply. And what that does is it says, look, a school, just like any other institution, can't discriminate against a child who has a disability. And so if there are certain services to make sure that that child is being treated equally as other students, we call them accommodations, is a 504 term, but if there are ways that that child can benefit and be more equal with their non-disabled peers, that all comes under 504. And then just two others that I'll mention, the Americans with Disabilities Act. Most people think that that's just a law that makes sure kids in wheelchairs or people in wheelchairs can access public buildings. Well, it is that, but it's much more than that, and it applies in the education context to, again, like 504, to make sure a child gets an equal education and they're not discriminated against. And then the last one, real briefly, is every state has its own anti-discrimination law. Pennsylvania has one, New Jersey has one, California has one, everyone has one. And that applies the same as the 504 and ADA laws, where you just can't discriminate against a child with a disability. And I'll say one more thing on the IDEA law, and this is very specific to dyslexia, and that is in October of 2015, and we talked about this at that dyslexia conference in Pennsylvania, but the U.S. Department of Education, Office of Special Education Rehabilitation Services, or we call it OSERS, came out with a guidance letter. And this was specific because a lot of schools were not using the word dyslexia. And that guidance letter said, you gotta use the word dyslexia if it's appropriate in an IEP. And the reason for that is because there are a lot of very specific services and special education that needs to be provided to kids with dyslexia, because that is a very, very specific and very special kind of disability that you need to tailor those services. Schools were not doing it, of course, because it costs them money. But the main point is that the U.S. Department of Education says you've got to use the word dyslexia.
And that was very important and a great step in the right direction for all of us.
Absolutely.
And how does anti-bullying play a role in IDEA?
Okay, that's a great question. So anti-bullying laws, and most states also have those as well, but basically bullying of children with disabilities we know is at a much higher impact than it is kids without disabilities. And I think it's as a result of their disability, basically, that kids know these kids have disabilities, so they're going to pick on them. Well, so IDEA law basically says, well, if a kid is a kid has a disability, kid has dyslexia, and they're being bullied by the school, and it's brought to the school's attention, and the school really doesn't do anything about that, that is a violation of IDEA law, and it's called what we call a denial of a free appropriate public education, or FAPE. And that is an IDEA violation, and you can actually sue the school for not doing anything about bullying these kids.
Okay, and it would be school bullying, not their friends, correct?
Right. In other words, so it can be bullying by their other peers at school. It can be bullying by teachers. It can be bullying of the teachers of the parents of these children with disabilities. It can come in various different forms, but yeah, absolutely. Now, and that's tricky, you know, because a lot of times friends will tease friends, but it's in a friendly, fun way. And we always have to make sure we're careful that this is really actually bullying and not just friendly teasing. But I think that's pretty easy to figure out.
And like, as a citizen, sometimes, you know, I'm worried about, you know, when you know, at a workplace, for example, we say hostile work environment, and it's a very fine line when you're joking with someone versus, you know, making that place a hostile environment for the other person. And I think schools are like that too. You know, most teachers are like to believe that they have the best intention in their heart for their students, but sometimes maybe they don't understand the difference between, you know, what might be bullying versus, you know, what is maybe criticizing the child. Could you give some examples so maybe those, you know, teachers and educators who are listening could also be educated on what's right, what's wrong, just like, you know, how we have to go through those trainings at work?
Yeah, absolutely. Great question and great point. And I will say that most of the time that it's not the teachers that are a problem, okay? And from my perspective as a lawyer and a parent, it's almost never the teacher's problem, because they like you said, they usually have the best interest of those child in their heart and in their minds. It's usually the school administrators. And so examples of this would be, you know, say a child may be struggling with dyslexia because they're having trouble on a reading assignment. And, you know, all of a sudden you hear a kid say, what's your problem? Can't you read the book? You know, what's going on? So that would be a clear-cut sign of bullying, okay? And that person, that kid who's saying that is not necessarily in that circle of friends that, you know, you can tell at school when a kid has a circle of friends, that person is or is not in that circle of friends. Whereas maybe an example of not bullying is, you know, says, you know, a friend says, oh, you know, hey, guess what? You know, I get letters mixed up all the time too. So, you know, we're all in the same boat. So it might be like a friendly, like, look, I understand you, almost an empathetic joke, so to speak. And you know, because they're in that circle of friends, that they're trying to relate to that friend and maybe even encourage them it may look to an outsider that that's potentially bullying, but if you see the whole circumstances as a teacher, you should be able to say, oh, okay, that's two friends who are kind of, talking with each other.
That makes sense. So maybe we can go through some examples, and we can start with an extreme. One of my readers said, wrote to me a while back, and she was saying that her state doesn't even recognize dyslexia. And I think they were a little bit lost on, what to do. And I believe it, if I remember correctly, it was Kansas. Is that true?
Yeah, well, so yeah, I see this all the time. Schools are not even recognizing dyslexia as a disability. And I, my first thing I say to parents is this: the law actually uses the word dyslexia in it, not just this Department of Education letter, but the law itself. And I'll bore you with a legal citation. It's actually 20 U.S.C. 14013. What that means is that's the federal law, that's IDEA, defining a child with a disability. And it has in there, it has examples of that, and one of them is dyslexia. It actually uses that word. Now, schools will say, well, yeah, I know it says that, but it's really not a disability. These kids are doing fine. Now, here's the tricky part, which is this. We know as a fact, most dyslexia kids are very, very bright kids, and sometimes can overcome that disability and still succeed in school. That doesn't mean they don't have a disability. That just means they've learned a way to cope. But as they go up in years in school, it may get harder and harder and harder. So therefore, that needs to be recognized as a disability. And schools need to be pointed towards IDEA law and say, it actually expressly includes dyslexia. So yeah, that's I see that all the time, and it makes me sad that schools take that position.
And now let's go to maybe another extreme where the school really wants to help, but they don't understand how they can help.
Yeah.
So how could a parent, being the most important advocate for that child, could help a school help themselves and help the child?
Absolutely. Great question. Great point. So there's a number of things. Number one, I think a lot of schools don't have the proper testing methodology to detect dyslexia or to determine its extent. So that's one way a parent can, and we'll talk about where they can get this information in a second, but parents can bring that information to the school and say, look, here's the right test to administer, or perhaps they've had their own physician or own testing done outside the school, and they can bring that to the school. That's one way. Another way is that to get information and bring, for example, some technologies or some teaching methodologies that will help children. So, for example, the Wilson Reading Program or Orton Gillingham programs that are very good for kids with dyslexia, and bring them and say, listen, these are programs that will help. And if you want to help, and we're gonna put this into an IEP, or we're gonna help provide these services, these are programs that I know will help my child. So for schools that are very cooperative, those are kinds of very helpful things they can bring to the table.
That's great information. And how about those schools in between? So there's some that are, they kind of accept it, but they don't know what to do, or they know what to do, but maybe they don't want to share the information until they're pushed by the parents who did their research, and they actually find a path for their child, and are insisting on getting the accommodations that they need. So what I have seen is it seems like there's a pattern to it, because some parents say we don't want to bring the lawyer for the first meeting. Some people say, I'm bringing my lawyer first time, so I get it right away. So what is a practical path for these parents? Sometimes parents do also feel like, my child will be in this school for a long time, will be with these teachers. I don't want to really start on the wrong foot. Of course, first of all, they should always be respectful, and should always respect that they might have some disagreements, but everything should be professional. Beyond that, so what are some of the advices that you can give based on your experience?
Right, that's great. So, and I agree with you, everything you said about, and I'd say, first make an attempt as a parent. Do your research, do your background reading, and bring those things to the table to an IEP meeting. So, for example, now, some parents, it's in their personality to kind of, to be forthright. And I don't mean that in a bad way. I just mean they're willing to speak up for themselves. But some parents are not. Some parents come into those meetings and they're very intimidated. So I would say the next step, after you've maybe presented that information to the school and they're not really fully accepting that, the next step would be to go to an advocate, okay? Now, there are paid and there are free advocates out there. Just always be really careful about the advocate. Make sure they understand your child to some extent. Make sure they understand dyslexia, and also make sure they understand the law. But they can come there and be a good advocate and for that parent. Where and I'll get about I'll get to the issue about attorneys in just a second, because that's very critical. But the advocate, starts off without it being an adversarial situation, but they can help the parent, take notes, suggest things to say, even offers, depending on the IEP team, even offer some input, because they can be a member of the IEP team with that parent. And that education advocate can be a great resource to say, well, ask for this kind of testing, or ask for this kind of reading program, and what have you. Now, the next step after that, if the advocate's not working, then you might want to consider being a lawyer. But I will say this, I almost never recommend a lawyer be brought to an IEP meeting. Two things happen that are, I think, negative. Number one, once a parent brings a lawyer to an IEP meeting, the school's allowed to bring their lawyer to the meeting. Then you got two lawyers in the room, and look, then you got nothing happening, right? Because you got a couple of lawyers yelling at each other. So that's number one reason. And number two reason is just that. You automatically start off the meeting in an adversarial position. And again, it's not going to be very productive. So now, in very, very difficult circumstances, I will go to an IEP meeting, but that's already if the parents have made several attempts to go. But it's very rare that an attorney should go to an IEP meeting. If you're at the point of meeting an attorney, you're probably ready to go to the next step, which is due process.
That's interesting. Yeah. So when I was talking to some of the parents I met through Decoding Dyslexia, it was interesting. One parent said that I bring an advocate to the meetings, but we get along very well with the school, but I'm so emotional that I don't remember anything we talked about. So I'm bringing someone who actually can take notes and can review this with me so I can understand, because what they're saying is not, I don't retain it after the meeting.
Yeah.
So it doesn't always have to be, you're on the edge with the school or things aren't going your way. Sometimes it's just a support person that you can bring along, and that can be explained to the school as well, saying I'm bringing an advocate, but it's not because, I want to, maybe, bring a support just for emotional reasons as well.
And that is such a great point, and that's true. Look, I even know this from my own experience as a parent. You walk into that meeting, it's intimidating. It's usually you and a group of like 10 people from the school. So it's a little intimidating. You might not know what to even expect, especially if it's your first IEP meeting. It's very emotional. It's you're the parent, you want the best for your child and so forth. So you're right. An advocate can offer a lot of things. Be objective and be there and not be emotional about the situation. Number two, they can be a note taker, because like you said, a lot of parents, they hear a discussion, but they can't remember it after the meeting because their emotions have been so high. But the advocate can be there taking notes and writing everything down so that can be the memory, so to speak, for the parent while they're there. And also, the parents might forget to ask a question, something might be very important for them. The advocate will be there and say, well, don't forget to ask this issue. And the parent will be very thankful that they haven't walked out of a meeting forgetting some of the most important things.
That's great points. So let's say things didn't work out and the lawyers are now, as you said, yelling in the room and the process starts. Can you take us through, what is that process and how it happens?
Okay, good. Yeah. So the next step is what we call due process. Okay. So that is where really you've come to loggerheads and you've got a dispute going on. The parent wants one thing, the school is suggesting another thing. So several things happen. So first of all, we determine, is this an IEP that is either, it's not well written and it doesn't include all the things we need, or it's okay with the IEP, I'm going to accept it as written, but there's still more things that they haven't included, or maybe they're not doing what they need to be doing that the IEP says to do. So now we're at a dispute level. So the first step that happens is we file what's called a due process complaint, or a request for due process hearing. Every state has their slightly different method for doing this, but it's basically the same. And it's basically, who am I, the parent? Who's the child? What's the child's date of birth? Where are they going to school? And a little bit more basic information, but then what's this dispute about? What's the problem? And you prepare this document. Very often it's good to get a lawyer involved at this point, because there's a lot of legalities here that people don't know, especially if they're not familiar with legal process. But that gets filed with the state agency, so the State Department of Education in almost all cases. The state then sits there and says, well, okay, let's try and resolve this dispute. So very often there's a period of about 30 days in which they get to try to work this out, try to settle this matter. And so they'll hold either a mediation or what's called a resolution session. Mediation is actually, the state sends a mediator there to kind of go between the parties, which I think is better than a resolution session, because again, it keeps the emotions down. A resolution session is just the parties talking with each other. Now, again, if there's attorneys, that's probably not going to go real far. So, and I will say, look, Pennsylvania is better than most states. I do work in both New Jersey and Pennsylvania. In New Jersey, they're almost all useless. But in Pennsylvania, the lawyers on both sides are usually very good, and it does get sometimes worked out then. If it doesn't get worked out in a 30-day period, it then goes on to basically a lawsuit, a traditional lawsuit, where it will get heard by a hearing officer, and you'll get so many days to prepare for that. It's just like putting on a trial. You want to put on witnesses, documents, and so forth, and then you get a trial. And if you succeed, great. If you don't succeed, well, you can always appeal it from there. So, and then it gets a little bit more complicated, but those procedures are pretty well set forth. Now, I'm going to make one more point, and this may be the most important part, which is this. If you have an IEP, say a year ago, and you were really satisfied with that, and it's now the new IEP that you're not satisfied with, you're not happy with it. Well, the first thing that takes place when you file that due process complaint, you should put in there language. The language is stay put, those two words, stay put. And why is that important? That means, look, we want that old IEP to stay in place. That's going to stay in place. And as long as this dispute goes on, that IEP is in place, because we know the new IEP is not good. And we don't want that IEP to be put in place. So it's very important, and that's one of those legal things that people don't always remember, but we lawyers know that's very important to put that stay put in place.
Well, that's interesting. So if you had an old IEP and the new one is not good enough, and then you're arguing on that, the old one just continues to be in place.
That's right, and that could even be for several years. If this goes on through the courts for a couple of years, that old IEP stays in place.
Interesting. Okay, that's a great point.
Yeah.
So I'm also assuming that there are parents who come out to you who maybe you don't go to the schools, but you might be guiding them through the process, and maybe give them some advice and tips on how they can proceed. So what are some of those, top points that you would say, parents should be aware of ABC?
Right. Okay. So that's great. Well, here's I think the biggest issue with most parents, and that is they want to put everything under the sun into this dispute. Okay. And so they forget that they actually have to prove every single one of those things under the sun. All you have to do is go into a Facebook discussion group, and you'll see these like 6-paragraph long explanations. Now, I understand that from a parent's perspective, absolutely. But here's my tip as a lawyer, and what I tell my clients is this. Pick out the most important parts of this, okay? Because it's going to be very difficult. If you have 30 things wrong, it's going to be very difficult for you as a parent, especially if I'm not coming as a lawyer, for you as a parent to try and prove all those 30 points. You know what's better? If you pick 4 or 5 points and they're very important and you have really strong evidence, pick out those 4 or 5 and make that what this case is about. That way it'll be easier for you to fight the battle. It might also encourage the other side to settle it a little bit faster. So that's definitely one point. Another point is this, and this may be a way to avoid a lawsuit, which is this. Think about evaluations. Everything in special education comes back to evaluations, okay? And so if the evaluations are a couple years old, then you might want to consider asking for new evaluations or reevaluations, okay? If the evaluation's fairly recent, but you're not satisfied with it, and that's the problem, there isn't a good IEP, you might want to ask for an independent evaluation. So those are things that I also recommend to clients before fighting the World War III battle. They can take that step, which also very often will resolve the dispute, resolve the problem. And this is a very important point on evaluations I want to make, because a lot of people don't know this. They hear the school say, well, triennial evaluation, meaning only every 3 years. Well, that's not what the law says. The law says they have to be done at least every 3 years, but not more frequently than every year. So in other words, there can be one every year. There can be one every 2 years. It does not have to wait for 3 years. And schools will tell you that because they don't want to spend the money. But the truth is, if the school is not really seeing some of the disabilities or some of the challenges your child has, that might be the right time for an evaluation.
That's interesting. So, what would your advice be for parents who did get the IEPs in place and they did work very well, and now the child is performing well at school, and then the school says, well, now he is doing well, he doesn't need this anymore, and knowing that he could fail again. So, you know, why the parents would be fighting, why do you take the necessary things around my child away for him to fail again, and then you would give those back once he fails?
Right. Yeah, that's true. And I see that happen quite a bit too. So the issue there is do they have the data to back up? Do they have the evaluation or the data to back up taking away the IEP or reducing the services? That's very important. If they don't have the data, then they can't do it. But if they do have the data that supports it, you got to be really careful, because remember, once you give up those if you agree to it, if you give up those special education services or curriculum, it's going to be a big challenge to get them back. Now, if you honestly think your child has overcome that disability or overcome those challenges, then you can work with the school, and that might be reasonable. But I'd say in 95% of the cases, that's not the case. And I'll tell you why. One big reason for that might be is, what is the curriculum that the school is giving that child? For example, I've seen many cases where children who have pretty severe disabilities, but they're getting all A's. Well, I'm going, wait a minute, how's that happening? Why is the child getting all these A's? Well, what they're doing is giving a 6th grader second grade curriculum, okay? And of course, they may be doing great on second grade curriculum, but that's not grade level. So again, that gets back to maybe asking the child to be evaluated. So do they have the data in the evaluations to really back up that change or reduction in services? And if they don't, then that might be another time to get an evaluation or get some new data, or maybe get an outside data to say, this child really is not at grade level. So, you know, you're the all A student. While I know that plays on the parent's pride and, you know, feels good, right? For a parent to say, hey, my kid's getting all A's. But if your kid's a 7th grader and getting all A's on second grade curriculum, that's a problem.
That's true, and that's something I think could be easily overlooked because we don't know sometimes what to ask.
Yeah.
Yes, that's true. So for those who are interested in finding you and reading more about your work and educating themselves, I know you have a book. Maybe you could share a little bit about your book and how we can find it, and I'll make sure that the links are in the bottom for them to click.
Great, thank you. Yeah, so my website is schoolkidslawyer.com. I have a lot of information there There's free forms, free legal forms. You want to request an IEP meeting. You want to request an independent evaluation. Those forms are there. You can download. I have a document I call the 5 Easy Steps to a Successful IEP Meeting. That's free to download down there. There's some other forms that are down there. I also have a blog that's there where I try to address key issues. And there's also a free newsletter that comes out once every month. I won't inundate you with emails. Once a month, you'll get an email with the newsletter that tries to pick 2 hot topics, but briefly discuss them. But thank you, and the most important part may be my book. And I'll give you a little background. When in about 2012, I started thinking about this and realizing that there's probably lots of parents who don't know the laws and don't know where to get help. So I said, I'm going to write this book. It took me a while to write it. It took me about a little over 3 years, but I went through the laws pretty carefully, and I wrote it really specifically designed towards the parent who knows very little or none about special education law. And I walk them through it from soup to nuts. We talked about a lot of the things that are in there: evaluations, independent evaluations, eligibility, child fine, and also disputes. When you actually have a dispute or IEP meetings, all that stuff is in the book, including forms and resources and things like that. Now, so it's available on Amazon.com. You can either go to my website, and there's a link there on my website to the book, or you can go directly to Amazon, and I know you're going to post that link to that Amazon.
Yeah, we'll make sure it's in the bottom as well.
Okay, great.
Well, thank you so much again for your time and all the knowledge that you shared with us so willingly.
Thank you. Thank you for having me. I really appreciate it.
Have a wonderful day. Thank you.
All right, you too.